Good morning, ladies and gentlemen. Welcome to the Interprofessional workshop of the Council of the Notariats of the European Union on the fight against money laundering and the prevention of the financing of terrorism. We have the pleasure to welcome you in this special format, in a digital format. It is the first time that we organize an event in this format, but we are very happy that we can reach out a lot of participants. We have more than 140 registered participants, which is, of course, a very good news. And they're from many legal professions which are concerned by the fight against money laundering and financing of terrorism. And this is why we actually would like to exchange on this topic with representatives of more professions from the legal field, from the public sector, from the private sector, from the European institutions. We have the pleasure to have today Ms Raluca Prună, who is the head of unit on financial crime at the European Commission, and who is the person who is best placed to tell us about the intentions of the European institutions about this issue. We have the pleasure to have the coordinator of the training program of the CNUE, which is actually gave us the occasion to organize this seminar, Mr. Mark Wilmus, who was recently appointed president of the Notaries Chamber of Brussels. So he's the president of the Notaries in the capital of Europe, and I would like to welcome him very warmly to the CNUE and to give him the floor for the welcome words. Thank you. Mark, please.
Bonjour à tous. Pour nous, c'est aussi une nouvelle expérience. On a dû apprendre à vivre avec nos masques et hélas, on a perdu le contact physique avec les participants et on espère que grâce à ce séminaire via vidéoconférence, nous pourrons avoir de très bons échanges entre nous. Comme vous savez, le programme de formation 3 que nous avons lancé maintenant il y a presque 2 ans réunit et a réuni plus ou moins 1500 notaires dans toute l'Europe. On a réuni non seulement des notaires, mais on a également réuni des juges, des avocats, des experts, fiscalistes et je dirais également des professions annexes aux professions citées. Les séminaires ont porté d'une part sur le problème du droit de la famille, les régimes matrimoniaux, et également sur la problématique du blanchiment d'argent. On est tous conscients dans tous nos pays que le problème du blanchiment d'argent est une matière nouvelle pour beaucoup de notaires, mais qui, ces dernières années, a pris énormément d'importance et aura encore des conséquences importantes pour le notariat ainsi que pour les autres professions. Cet ensemble de séminaires a été réalisé dans différents pays d'Europe. Je dirais énormément de pays ont organisé des séminaires du droit de la famille. Je cite entre autres l'Autriche, la Belgique, l'Allemagne, l'Espagne, la France, la Grèce, l'Italie, les Pays-Bas, le Portugal, la Roumanie et la Slovénie. Pour le blanchiment d'argent, déjà 8 séminaires ont eu lieu. La Belgique, la Pologne, la Lituanie, les Pays-Bas, Malte, Portugal, Roumanie, Slovénie. Encore un séminaire aura lieu après celui-ci le 15 octobre en Italie sur la matière du blanchiment d'argent. Évidemment, avec la crise du corona, un séminaire a dû être annulé en Estonie. On le regrette, mais je dirais quand on voit le retour qu'on a eu de ces différents séminaires, on constate qu'il y a vraiment une nécessité d'organiser des séminaires dans ces matières très techniques du blanchiment d'argent, car les conséquences peuvent être très importantes, encore une fois, comme je le répète, pour les notaires de l'Europe. Il y aura également une visite de la Cour européenne qui était prévue au départ dans le courant du mois d'octobre, début novembre. Cette cérémonie de clôture aura probablement lieu avant le 30 novembre. Une confirmation sera envoyée encore à la CNUE puisque nous attendons le feu vert du Luxembourg à cet égard. Alors, vous constatez que plus de 1500 notaires ont participé à nos séminaires. C'est une matière, comme je l'ai dit, qui est vraiment très vaste et qui nécessitera encore pour beaucoup de notaires des approfondissements. Alors, je tiens ici à passer la parole à M. Rouskas, président de la CNUE. J'espère qu'il est connecté et que nous pouvons lui transmettre la parole. Voilà, on me dit que ça vient. C'est ça la technique.
Συμμετέχοντες, εκλεκτοί συμμετέχοντες, αγαπητοί συνάδελφοι, με χαρά σας καλωσορίζουμε εμείς οι Ευρωπαίοι Συμβολιογράφοι στο πρώτο CNUE webinar για την καταπολέμηση του ξεπλήματος του μαύρου χρήματος. Είμαστε ιδιαίτερα ικανοποιημένοι που σαν Ευρωπαϊκή Συμβολιογραφία διαπιστώνουμε ότι μπορούμε να υπολογίζουμε στην μαζική συμμετοχή όλων των Ευρωπαίων συμβολιογράφων, αλλά οπωσδήποτε είμαστε υποχρεωμένοι και διαπιστώνουμε ότι είμαστε υποχρεωμένοι οπωσδήποτε να συνεργαστούμε με μια σειρά άλλα επαγγέλματα, όπως είναι η φοροτεχνική, οι δικηγόροι, οι δικαστές, εκπρόσωποι του τραπεζικού συστήματος, των εποπτικών αρχών, της Interpol, ακόμα και της Ευρωπαϊκής Επιτροπής οπωσδήποτε, ειδικά στο πρόσωπο της κυρίας Ραλούνα Προύνα, επικεφαλής της σχετικής Επιτροπής της Ευρωπαϊκής Ένωσης. Αλήθεια είναι ότι στις 7 του Μαΐου η Ευρωπαϊκή Επιτροπή μας παρουσίασε το δικό της νέο σχέδιο δράσης για την νομιμοποίηση εσόδων από παράνομες συγκεκριμένες δραστηριότητες και την χρηματοδότηση της τρομοκρατίας. Το εν λόγω σχέδιο δράσης οπωσδήποτε ορίζει και καθορίζει συγκεκριμένα μέτρα που είναι υποχρεωμένη να λαμβάνει η Επιτροπή για την καλύτερη εφαρμογή, την εποπτεία και τον συντονισμό των κανόνων της Ευρωπαϊκής Ένωσης στον τομέα του ξεπλήματος του μαύρου χρήματος. Αλήθεια είναι ακόμα ότι οι Ευρωπαίοι συμβολιογράφοι είναι ένας από τους βασικούς παράγοντες στον ευρωπαϊκό αγώνα ενάντια στο ξέπλυμα του μαύρου χρήματος. Στην Ευρώπη ως δημόσιοι λειτουργοί βρίσκονται στο κέντρο νομικών ενεργειών και συγκεκριμένων ρυθμίσεων για τις συναλλαγές ακινήτων, τη σύσταση εταιριών και τη μεταβίβαση αυτών, οι οποίες αποτελούν διάβλο οπωσδήποτε για πράξεις νομιμοποίησης εσόδων από έκνομες δραστηριότητες. Είμαστε υποχρεωμένοι και εφαρμόζουμε τις συστάσεις της ΦΑΤ και την ευρωπαϊκή νομοθεσία που προκύπτει. Οι συμβολιογράφοι έχουμε εμείς λοιπόν οι συμβολιογράφοι την υποχρέωση και το υλοποιούμε να ενημερώνουμε τις δημόσιες αρχές των εθνικών κρατών αλλά και σε ευρωπαϊκό ελπίζουμε επίπεδο για οποιασδήποτε υποψίες που ενδέχεται να έχουν σχέση με μία οικονομική συναλλαγή ή και οικονομική πράξη. Για το λόγο αυτό η Ένωσή μας, η Ένωση Ευρωπαίων συμβολεογράφων. Με πολύ μεγάλο ενδιαφέρον είμαστε υποχρεωμένοι να παρακολουθήσουμε και παρακολουθούμε τις συζητήσεις για το σχέδιο δράσης και οπωσδήποτε συμμετέχουμε σε οποιαδήποτε δημόσια διαβούλευση. Θα βρείτε λοιπόν τη συμβολή μας σε αυτή την συγκεκριμένη διαβούλευση στην ιστοσελίδα της Ευρωπαϊκής Επιτροπής και θα ήθελα για αυτή την δική μας ευρωπαϊκή συμβολεογραφική συμμετοχή να υποστηρίξω αυτή τη συμμετοχή μας με την εξής επιχειρηματολογία. Χαιρετίζουμε οπωσδήποτε τη συγκεκριμένη προέγγιση της Επιτροπής. Αλήθεια είναι ότι οι οικονομικές ζημιές που προκαλούνται από το ξέπλυμα χρήματος είναι εξαιρετικά μεγάλες, τεράστιες και η κίνδυνη χρηματοδότηση οποιασδήποτε μορφής τρομοκρατίας είναι ολοφάνερη. Για τους συμβολεογράφους, η καταπολέμηση αυτού του είδους φαινομένων αποτελεί βασική μας προτεραιότητα. Η καταπολέμηση της νομιμοποίησης εσόδων από τις παράνομες συγκεκριμένες δραστηριότητες μπορεί να είναι αποτελεσματική μόνο αν οι ισχύοντες κανόνες της Ευρωπαϊκής Ένωσης αντιμετωπίσουν την έλλειψη συνοχής την οποία θα μπορούσαν να εκμεταλλευτούν οι εγκληματίες για τις παράνομες δικές τους ενέργειες. Αυτός είναι ο συγκεκριμένος λόγος για τον οποίο κάθε κράτος μέλος μας είμαστε υποχρεωμένοι να μεταφέρει στο εθνικό του δίκαιο την 4η και την 5η οδηγία για την καταπολέμηση της νομιμοποίησης εσόδων από έκνομες δραστηριότητες. Ως αποτέλεσμα αυτού, λοιπόν, η CNUE εκφράζει την απόλυτη ικανοποίησή της για τη δέσμευση της Επιτροπής να ξεκινήσει διαδικασίες για τις παραβάσεις οι οποίες λαμβάνουν χώρα σε αυτόν τον συγκεκριμένο τομέα. Ωστόσο, είμαστε υποχρεωμένοι να έχουμε υπόψη μας ότι τα περισσότερα κράτη-μέλη της Ευρωπαϊκής Ένωσης έχουν ήδη μεταφέρει στο εθνικό τους δίκαιο αυτές τις συγκεκριμένες οδηγίες, δηλαδή για την καταπολέμηση της νομιμοποίησης εσόδων από έκνομες δραστηριότητες. Και σε ορισμένες περιπτώσεις τα εθνικά μας δίκαια εισάγουν αυστηρότερες διατάξεις από εκείνες που ορίζουν οι οδηγίες. Σε αυτές ανήκουν ως παράδειγμα οι εκτεταμένες υποχρεώσεις υποβολής εκθέσεων με τις οποίες οι Γερμανοί συμβολεογράφοι οφείλουν να τις ακολουθούν λοιπόν στον τομέα ακινήτων. Από την άλλη πλευρά έχουμε την πολύ επιτυχημένη ενέργεια και τα αίσια αποτέλεσματα από τη λειτουργία σχετικής ηλεκτρονικής πλατφόρμας από τους συναδέλφους της Ισπανίας, η οποία ισπανική συμβολεογραφία, χρησιμοποιώντας μια σύγχρονη λύση Big Data, είναι σε θέση να υποστηρίξει τους Ισπανούς συμβολεογράφους για την καταπολέμηση αυτής της συγκεκριμένης δραστηριότητας. Είναι μια συγκεκριμένη δραστηριότητα που αξίζει να την ελέγξουμε και να την παρακολουθήσουμε όλοι. Είμαστε λοιπόν υποχρεωμένοι να έχουμε στην ευρωπαϊκή σκέψη ότι η εναρμόνιση ορισμένου τομέου δικαίου μέσω ενός συγκεκριμένου κανονισμού θα ήταν σε θέση, οπωσδήποτε θα μπορούσε να οδηγήσει σε μείωση του επίπεδου των υποχρεώσεων που ισχύουν ήδη σε ορισμένα εθνικά κράτη-μέλη. Αυτή η συγκεκριμένη εξειδικευμένη κατάσταση είμαστε υποχρεωμένοι να την αποφύγουμε. Είμαστε όμως και απόλυτα συμφωνούμε ότι το νομικό πλαίσιο της Ευρωπαϊκής Ένωσης θα ωφεληθεί από έναν βαθμό εναρμόνισης. Για παράδειγμα, ο κατάλογος των υποχρέων οντοτήτων, είμαστε υποχρεωμένοι να υπολογίζουμε ότι ομοιόμορφα θα ρυθμίζεται, ιδίως όσον αφορά την αντίδραση στις εξελίξεις στον ψηφιακό τομέα, για οποιαδήποτε ηλεκτρονική πλατφόρμα υφίσταται ή για οποιουσδήποτε συγχρόνους, δηλαδή συγχρόνους παρόχους υπηρεσιών για οποιαδήποτε πληρωμή. Αν όχι, τότε οπωσδήποτε θα έχουμε συγκεκριμένα κενά που θα δημιουργήσουν δυσαρμονίες. Θα ήταν επίσης σκόπιμο να εναρμονιστούν όλα τα καθήκοντα των μονάδων χρηματοοικονομικών πληροφοριών. Αυτές οι μονάδες οπωσδήποτε θα πρέπει να υποστηρίζονται από την Ευρωπαϊκή Ένωση και σε οικονομικό όσο και οργανωτικό επίπεδο και οπωσδήποτε να είναι διασυνδεδεμένες. Επιπλέον, οι εναρμονισμένες υποχρεώσεις υποβολής εκθέσεων είναι απαραίτητες για την καταπολέμηση του συγκεκριμένου εξειδικευμένου έκνομης δραστηριότητες σε ολόκληρη την Ευρωπαϊκή Ένωση. Οπωσδήποτε στην πραγματικότητα, εάν οι υπόχρεες οντότητες σε μεμονωμένα κράτη-μέλη δεν ήταν υποχρεωμένες να αναφέρουν ορισμένα γεγονότα, αυτό θα δημιουργήσει οπωσδήποτε μια δύσκολη κατάσταση σύγχυσης. Θα ήταν επίσης λογικό να συμπεριληφθεί σε ένα κανονισμό όλα τα μητρώα λογαριασμών της Κεντρικής Τράπεζας, όπως θα ήταν ιδιαίτερο χρήσιμο για τις αρχές επιβολής της συγκεκριμένης νομοθεσίας όσον αφορά τον εντοπισμό της νομιμοποίησης εσόδων από παράνομες ενέργειες και με τη μεγαλύτερη διαφάνεια στη ροή του χρήματος σε διασυνοριακές επαφές, οπωσδήποτε και σε σενάρια. Ωστόσο, άλλες πτυχές της καταπολέμησης, της νομιμοποίησης λοιπόν αυτών των εσόδων, οπωσδήποτε οφείλουμε να προσφέρουν επαρκή περιθώρια στα εθνικά κράτη όσον αφορά την εφαρμογή τους. Δεδομένου ότι ένα υπερβολικά αυστηρό νομικό πλαίσιο της Ευρωπαϊκής Ένωσης θα ήταν πιθανό να τους εμποδίσει να αναπτύξουν λύσεις για την αντιμετώπιση του ξεπλήματος μαύρου χρήματος. Άρα είμαστε υποχρεωμένοι να λάβουμε υπόψη μας και τις εθνικές ιδιαιτερότητες. Όλα τα κράτη-μέλη λοιπόν θα πρέπει ιδίως να συνεχίζουν να ρυθμίζουν τις απαιτήσεις δέουσας επιμέλειας των πελατών τους. Οι συγκεκριμένοι κανόνες για την ηλεκτρονική ταυτοποίηση και εξακρίβωση, οπωσδήποτε είμαστε υποχρεωμένοι να την αφήσουμε στα εθνικά κράτη-μέλη. Από αυτή την άποψη υπάρχει επί του παρόντος ο κίνδυνος ένας ευρωπαϊκός κανονισμός να βασίζεται σε ένα χαμηλό ελάχιστο πρότυπο, το οποίο δεν θα πληρεί τα υψηλά πρότυπα της συμβολιογραφικής παρέμβασης. Αλήθεια είναι ότι το Ευρωπαϊκό Συμβολιογραφείο αλήθεια είναι ότι η Ένωση Ευρωπαίων Συμβολιογράφων αναπτύσσει επί του παρόντος εξαιρετικά ασφαλείς διαδικασίες ταυτοποίησης για την επιγραμμική σύσταση των εταιριών περιορισμένης ευθύνης. Ο κανονισμός δεν θα πρέπει σε καμιά περίπτωση να υπονομεύσει αυτά τα συγκεκριμένα συμβολιογραφικά πρότυπα. Η εποπτεία είναι ένα άλλο σημαντικό ζήτημα. Τα αυστηρά και λειτουργικά συστήματα εποπτείας είναι σαφώς απαραίτητα για την αποτελεσματική εκπλήρωση των υποχρεώσεων για το ξέπλυμα του μαύρου χρήματος. Δεδομένου ότι οι συμβολιογράφοι υπόκειται ήδη σε αυστηρό έλεγχο σε εθνικό επίπεδο, συνήθως διεξάγεται από τις δικαστικές αρχές, η Ένωση Ευρωπαίων Συμβολιογράφων έχει την άποψη και προτείνει ότι η υψηλή ποιότητα της σημερινής δομής εποπτείας των τοπικών αρχών δεν θα πρέπει να τεθεί σε κίνδυνο από ένα πρόσθετο ευρωπαϊκό επίπεδο. Κατά τη δική μας γνώμη, μια κεντρική εποπτική αρχή της Ευρωπαϊκής Ένωσης οπωσδήποτε θα πρέπει να έχει άμεσες εξουσίες μόνο στον χρηματοπιστωτικό τομέα και να στηρίζει επιπλέον τα κράτη-μέλη μέσω της ανταλλαγής γνώσεων, πληροφοριών και εμπειριών. Εδώ θα ήθελα να πω με λίγα λόγια η θέση της Ένωσής μας σχετικά με το σχέδιο δράσης της Ευρωπαϊκής Επιτροπής και τις προτάσεις που αυτή τη στιγμή συζητάμε. Αυτή είναι η θέση μας. Είμαστε απόλυτα πεπισμένοι και πεπισμένος ότι μέσω του διαλόγου με τη συμμετοχή όλων των ενδιαφορομένων φορέων, νομοθέτη, εποπτεύων και υπόχρεων οντοτήτων, θα είμαστε σε θέση να επιτύχουμε ένα αποτελεσματικό πλαίσιο για την καταπολέμηση της νομιμοποίησης εσόδων από παράνομες δραστηριότητες και τη χρηματοδότηση της τρομοκρατίας. Σας ευχαριστώ. Εύχομαι τη μεγαλύτερη επιτυχία στην σημερινή μας σεμιναριακή διαδικασία. Σας ευχαριστώ όλους και πάλι.
Alors, Monsieur le Président, je vous remercie beaucoup pour votre intervention et les nombreux éléments que vous avez déjà donnés. On est convaincu, presque dans tous les pays, que finalement une coopération européenne est indispensable dans cette matière. Je suis sûr que dans tous les pays, on est conscient qu'en tant que notaire et que nous sommes en qualité d'officier public, nous avons un devoir de lutter contre cette problématique du blanchiment d'argent. Je dois également signaler que grâce à la Commission européenne, nous avons trouvé des budgets et la Commission nous apporte énormément de soutien pour organiser ces différents séminaires. Sans la Commission européenne, tout le travail qu'on fait actuel n'est pas possible. C'est pour ça que je donne la parole, si vous permettez, à Madame Raluca Prună, chef d'unité de la DG FISMA, laquelle intervient ici pour représenter la Commission européenne. J'espère qu'elle est en ligne. Voilà, bonjour.
Thank you. Good morning, everyone. I hope you hear me. First of all, very much for having invited me to attend this seminar. It's an honor and a pleasure for me to address this audience. As the President Ruska said before, the Commission is embarked in a very ambitious agenda to reform the AML-CFT policy in the European Union. If you allow me, I would say from the outset that we all know that at least billions of euros on a yearly basis are passing through the financial system, and some of them relate to criminal activity. Reference was made earlier by President Ruskas to the fact that there is a lot of dirty money, if I may say so, infecting our financial system. Indeed, we have figures from Europol pointing at the fact that we speak about 1% of the EU yearly GDP on each year. So the Commission took action in a context in which, as you know, starting with the adoption of the fifth AMLD, with the context in which there were many terror attacks in Europe, We also had to table this fifth AMLD just to address challenges at that moment. Then in 2018, it so happened that unfortunately we had waves of difficult situations, not to say scandals, that erupted through the Union financial system involving many European banks. As a result, the Commission was asked by the Council to present a report. And last year in July, the Commission adopted a package, an AML package, including, among other things, a report that was called the post-mortem report, giving, you know, a snapshot of what happened in the financial system and what happened with the concrete scandals that I referred to. The reports and in general the AML package last year pointed at fragmentation of rules across border, as it was rightfully said before. It is the case that when we have a directive, member states may go beyond what the minimum harmonization level established in the directive. So it is the case also in this field. We have fragmentation. The package also pointed at insufficient supervision that operates and rules that are applied differently by different supervisors in different member states, and insufficient coordination and exchange of information among the financial intelligence units. For all these reasons, the Commission announced that while there is indeed a lot of room for better enforcement by the member states, because they are at the front line of applying, of enforcing the AMLD legislation at union level. So beyond enforcement, structural changes can only be addressed by a new reform and perhaps new rules. It was announced, therefore, in late last year that AML CFT, this policy, is a high priority for this Commission, for the Executive Vice President Dombrovskis, whose mission letter encompassed this objective of proposing an ambitious, comprehensive AML CFT policy. What the Commission has done was indeed to adopt on the 7th of May the action plan on this comprehensive AML CFT policy. We are of the view that this plan is ambitious. It's multifaceted as it accounts for all aspects of fighting money laundering and terrorist financing, from enforcement to the role of the Union in the international fora. First of all, this action plan accounts for indeed better application, better implementation of existing rules, because no rule serves no purpose unless it is properly applied. And fact is that we have at Union level many directives, the last of which is the fifth that amended the fourth directive. And I will not be shy in addressing to you and saying that it was difficult for member states to transpose these directives. We have opened infringements, it's a public knowledge. And we are in the Commission, we are pleased to see that the infringement proceedings and the extensive discussions that we had with member states allowed member states to have more or less rules transposed by the book. But this is not enough, and we need to now see the rules effectively functioning in practice. A second pillar in the action plan is on supervision. And here I think that it is important for all, including for notaries, because notaries are obliged entities, to know that supervision as it currently works in the Union, it's not very effective. Indeed, the scandals in the banks last year pointed that supervision in the financial sector. I will not insist here today. But we also know, and we know from the supranational risk assessment that we are publishing every second year, that the non-financial sector, the so-called DNFBPs, the designated non-financial businesses and professions, they're also in the front line, and they may be exposed, they are exposed to money laundering and terrorist financing. So this is the policy. Why I say that? I say that because when we have, we've taken a look at the situation, to map the situation in the Union, and we have seen that we speak about many thousands, if not more, of obliged entities, about different supervision in different member states, about legal professions being supervised legal profession supervising itself, which is fine because we speak about legal profession and liberal, so-called the profession libérale. But however, the situation is uneven at the level of member states. I will come back to that because I would like to quickly go through different layers, different pillars in the action plan. This brings me to another pillar, which is about a single rule book. And as indeed President Ruska said before, it was challenging for member states to transpose the directive. We have seen fragmentation. We have seen member states that went beyond the directive, which is perfectly legitimate because member states can gold plate and can provide higher standards on their national territory than the minimum harmonization in directives. But the result at Union level is that we have fragmentation of rules, and we think that at least for a number of issues in the directive, there is scope for more harmonization. So there is scope for a regulation. When I say regulation, this is by no means to say that the regulation will provide a higher level of harmonization, but it will not, for instance, not provide a rule book approach for what is CDD, the customer's due diligence. So CDD is one of the elements that will be certainly harmonized more in a regulation. But again, it will not be the case that you will see in the forthcoming regulation a list of issues that have to be ticked to do CDD. Because as you know, CDD is to be performed on a risk-based approach. This is the principle that FATF is requesting. And this is making our task, if I may share this with you, very difficult. Because we cannot come with a set of rules that have to be followed by each obliged entity to do, complete, full, effective CDD. And this is left to, we have a set of rules, but the risk-based approach, the identification of the riskiest clients are to be still in the hands of the obliged entities. There are other pillars in the action plan, but I think that they're less important for the purpose of the meeting here today, but I will briefly refer to them. We have a pillar accounting for the financial intelligence units, because you as obliged entities and all other obliged entities, you
on a un problème pour le
lost
moment.
my connection.
Voilà. On a un problème de connexion maintenant à Internet.
Vous m'entendez maintenant?
Oui.
On vous entend, mais on ne vous voit pas. Ah, ça arrive, paraît-il. Voilà, OK. Ça marche.
Ça marche? Oui, désolé. I was about to say that obliged entities are reporting suspicious transactions to financial intelligence units, and we have heard many times that this is a challenging issue. Why is it challenging? When we speak to obliged entities, they will tell us, be it in the financial sector, be it in the non-financial sector, notaries, lawyers, accountants, fiscal consultants, they all tell us we report to the FIUs, but we often don't have a timely feedback. So we do not know whether what we report as suspicious transaction was indeed useful for the FIU, was indeed followed by the FIU, and this has to be addressed. If you speak to the FIUs, on the other hand, they will tell that they are flooded with hundreds of thousands in some member states, in big member states, of suspicious transaction reports, and they cannot find their way to identify typologies in this magnitude, in this volume of suspicious transaction reports. And this is why the action plan announced that measures a support and coordination mechanism for FIUs that will allow FIUs in Europe to do more of joint analysis, to identify typologies, and indeed to fight financial crime, which is a cross-border phenomenon, with cross-border means. We also have in the action plan a pillar accounting for enforcement, effective enforcement, investigation, but also ways of improving cooperation between the public and the private sector through, for instance, the public-private partnerships. And last but not least, there is an international aspect of the AML-CFT policy, and the action plan speaks about a bigger role, a stronger voice of the EU on the international, in international fora, more specifically in FATF. So this is what we have, what the Commission announced in this ambitious action plan. The action plan was adopted on the 7th of May. It was followed by extensive public consultation throughout the summer. We have closed the public consultation through a hearing a couple of days ago on the 30th of September with high-level participants. The hearing was chaired by the Executive Vice President Dombrovskis, but we had attendance from the Presidency of the Council, now from the German Presidency, from the Parliament, and high-level participants from think tanks and from national authorities. I will close my short presentation today by saying that we are now in a very challenging time in which money laundering is exposed quite often in the headlines. You have seen perhaps the FinCEN leaks, and we see that, you know, the system is not bulletproof, and the system is as strong as its weakest point. So the Commission announced these measures. We have done the public consultation. We have received numerous contributions, including from notaries, and I take the opportunity to thank you for your contributions. And now time is for us to put all this together. We have heard stakeholders. We have bilateral exchanges with stakeholders, and now again, time is for us to put all this together in an impact assessment and to table proposals by early 2021. It will not be easy. It was a thorough process, but I believe that having the support of the Council, we have Council conclusions that were adopted in December last year. With the support of the European Parliament, we have a resolution adopted in July this year. We have a political momentum and political expectations from stakeholders to address, again, financial crime as a cross-border phenomenon. We know that criminals are always ahead of us, of policymakers and regulators, and we have to give a strong response to a phenomenon which is not light and which accounts for dirty money infecting our financial system and putting into question the effectiveness of our policies. I will stop here, and I would be happy to take your questions and reply to the best of my knowledge. Thank you. I cannot hear you, but I think that I'm still connected.
Can you hear me now?
Yes, I can hear you now. Thank you,
Okay.
Mr. Rădoi.
Thank you very much, Mrs. Prună. Mulțumesc foarte mult for your very interesting insights on the intentions of the European Commission regarding the fight against money laundering. I would like to invite the audience to ask a few questions. I know that you have another important meeting today, but still, if you can stay a few minutes with us, maybe there are questions from the audience. People can use French, English, and Greek language. And please raise your hand via the participant button in the Zoom conference in order to register for questions. And we are going to give you the floor and allow your camera, please, for the questions. Are there questions? I'm asking my colleagues from the technical staff.
Oui. Bonjour, donc nous avons une première question de Zoazi Schledan. Pensez-vous que dans l'avenir, une autorité de supervision européenne sera créée pour uniformiser les contrôles?
Je peux répondre maintenant ou on prend plusieurs questions?
Non, allez-y maintenant.
Oui.
Oui,
bon, merci pour la question. Si je peux dire ainsi, c'est une question assez récurrente qu'on reçoit. Et la Commission avait annoncé qu'il n'y a pas de solution qui va pour le secteur financier et non financier. Alors, l'ambition de la Commission est de se concentrer selon le mandat qu'on avait reçu des États membres et du Parlement, de prioriser le secteur financier et de d'essayer de proposer un superviseur européen qui ne remplace pas, et je dis bien qui ne remplace pas les superviseurs au niveau national, mais qui travaille avec eux et qui, pour les institutions financiers qui présentent le risque le plus important, qui pourra faire de la supervision directe en coordination avec les superviseurs au niveau national. Ceci étant dit, c'est clair que pour le secteur financier qui est beaucoup plus intégré, pour lequel on a le SSM, on a pour la supervision en matière prudentielle des institutions financières, on a un acquis européen qui est beaucoup plus avancé et une intégration beaucoup plus avancée. Ce n'est pas le cas pour les professions.
C'est uniquement nous, Marc. C'est uniquement nous.
Sur Internet, ça se voit ou pas?
Je suis de retour. Je ne sais pas si c'est mon... Mille excuses pour tout le monde. Je ne sais pas si c'est mon système ou... Je disais que pour le secteur, j'étais en train de dire que pour le secteur non financier, les choses sont un peu plus compliquées parce que dans le non financier, on a une multitude de obliged entities, entités assujetties. Et là, c'est beaucoup plus difficile. On a des professions libérales comme la vôtre, comme les avocats, comme les consultants financiers. Et là, on ne peut pas venir avec une entité centralisée qui pourra remplacer ce qui est fait au niveau national. Là, sans préjuger du résultat, parce qu'on est en train de faire une étude d'impact et de voir ce que dans la consultation publique, quelles sont les attentes et les suggestions des stakeholders. Là, je peux dire qu'il n'y aura pas, sans préjuger encore une fois, il n'y aura pas de supervision directe, pas du tout. Mais on est en train de voir si c'est possible de créer au niveau européen une manière de s'assurer que la supervision dans le secteur non financier, qu'il n'y a plus de coopération, plus d'échange des bonnes pratiques et que, si possible, mais on n'en est pas encore là, je partage avec vous en pleine transparence ce qu'on avait reçu dans la consultation publique, quelles sont les attentes de certains des interlocuteurs, qu'on puisse créer au niveau national une sorte des entités, disons, de droit public qui pourront éventuellement assurer une supervision indirecte des professions non financières. J'espère que j'ai répondu.
Merci beaucoup. Est-ce qu'il y a d'autres questions, chers collègues de l'équipe technique?
Oui, nous avons une autre question de M. Pascal Morin. Bonjour, pour quelles raisons les entités transmettant des informations n'ont-elles pas de retour des autorités de contrôle?
Oui, je ne sais pas si vous voulez répondre.
Je peux répondre, hein. Je peux répondre sur base des informations qu'on avait, des réponses qu'on avait reçues et des discussions qu'on a depuis plusieurs années maintenant avec les cellules de renseignement financier, et avec les superviseurs et avec les entités assujetties. Comme j'avais dit, ça dépend à qui on parle. Si on parle aux autorités publiques, ils nous disent on est submergé des transactions suspectes, suspicious transaction reports, et alors ça prend du temps de faire toute cette analyse et d'avoir un retour au niveau des entités assujetties. Et c'est pour ceci, on est bien d'accord qu'il y a pas mal même voire un volume très important de rapports de transactions suspectes. Et on ne peut ni demander aux entités assujetties de limiter un tel retour vers les cellules de renseignement financier, parce que ça va de la force de la directive et de la loi nationale qui la transpose. C'est une obligation des entités assujetties de transmettre aux cellules de renseignement financier tout rapport, toute transaction qui semble suspecte. Et là, le défi qu'on a, c'est d'essayer de faciliter la vie et le travail des cellules de renseignement financier, tout en respectant la manière dont ils sont organisés au niveau national, leur indépendance, leur autonomie, mais d'essayer de faciliter les échanges et d'essayer de mettre ensemble les différentes pièces, disons, d'informations afin qu'ils puissent avoir un retour et afin qu'ils puissent identifier des typologies. Et si vous me permettez 30 secondes pour donner un exemple. Depuis que la crise sanitaire COVID-19 avait commencé, on avait eu des réunions avec les cellules de renseignement financier, les FIUs, et tous ont partagé, par exemple, le fait que pendant la crise, la typologie la plus récurrente, ça concernait des transactions des fraudes, par exemple, ou des transactions avec des équipements, de l'équipement médical qui n'était pas conforme aux normes, qui venaient de certains pays de l'Asie. Et alors, pour ce type disons, quand on voit qu'au niveau de tous les États membres, toutes les cellules de renseignement se confrontent avec la même typologie, on se dit quand même qu'il faut faire en sorte qu'au niveau de l'Union européenne, on puisse créer des mécanismes de coopération pour que l'information entre les cellules de renseignement circule plus facilement, pour que, par exemple, je ne sais pas dire ça en français, rogue traders, qui profitent des points faibles de nos systèmes et qui le font dans plusieurs États membres, qu'on puisse mettre tous ces éléments ensemble, les FIUs bien évidemment, afin de donner une réponse coordonnée à un problème qui est la criminalité financière et qui est un problème complexe et certainement qui dépasse les frontières de l'État national.
Merci beaucoup, Madame Prună. Nous avons une autre question, si vous avez encore le temps, de Madame Corinne de Certaines-Brossard. Pourrait-il y avoir une contrainte de la Commission européenne pour une meilleure communication du domaine financier avec les notaires?
Je ne suis pas sûre si j'ai bien compris la question. Est-ce qu'il y a une contrainte pour une meilleure communication entre la Commission et les notaires?
Could it be?
Could it be?
Could we have a yeah.
Well, there is no constraint. I mean, I acknowledged in the first part of my presentation that notaries, like lawyers, are let's say, non-designated, are liberal professions. And as such, they have a degree of autonomy which is confirmed by also at the European level by court cases, and this we do not intend to challenge. But through exchanges like this, we are certain that we can, you are best placed to tell us what are the most, let's say, recurrent problems that you encounter in your reporting obligations stemming from the AML CFT, from the directive. We have heard, and I think that reference was made earlier by President Ruskas, on the fact that in Germany, for instance, notaries have obligations which go beyond, they're stricter than the directive provides for when it comes to real estate. I do not know, I do not know whether this is the case in other member states, but what I know for certain, what we know, and we said it so in the supranational risk assessment, is that in the case of real estate, we have seen and lawyers and notaries being exposed, and we have cases that are reported by, I mean, not cases, not cases in the sense of criminal cases, but situations, recurrent situations that are reported to us by big cities in Europe. There is a coalition of cities, Amsterdam, if I'm not wrong, Göteborg, Barcelona, and Berlin. They have organized conferences just to point at the fact that a way of laundering money in their own city is to buy properties, real estate, with bags of money. And here I think that, you know, notaries are, and lawyers for that purpose, are the first exposed and the first to tell us a bit, to share with us, we're policymakers, whether this is recurrent, whether this is a problem, whether, I don't know, we should consider putting a limit to the use of cash in Europe. Some are requesting this, some are not really concerned because they're linking this to privacy and to the right of privacy, the use of cash. So there is, just to sum up, there is no constraint, but quite on the contrary, we welcome your feedback, because the ambition in this reform is to do a reform that really replies to expectations. The reform that any policymaker is doing without replying to these expectations will not be a reform that will be efficient in practice. So no constraint. Please share with us whatever you think that would merit to appear in this reform and to make the situation a bit better, because this is about this reform. We want to improve things.
Thank you very much for your answers and for your availability to give us these insights. I would like now, if you allow me, a last question, turn to President Vilmos, who is coming from a big metropole, from Brussels, and who would like to ask you a question.
Oui, je vais encore vous embêter pour une petite question, parce qu'on constate, nous, au niveau de la Belgique, que nous avons un organisme indépendant qui a été créé, qui s'appelle la CETIF, et qui est chargé du problème de blanchiment d'argent et de toutes les informations à recueillir des différentes autorités. On constate, quand on voit les statistiques, que les banques jouent le jeu, on constate que les notaires jouent le jeu, déposent des informations, mais on constate, hélas, que les professions d'avocats ne jouent pas du tout le jeu en Belgique. Très peu d'informations sont communiquées par les avocats. Est-ce que vous avez déjà eu cette question soulevée au niveau de l'Europe? Parce que nous, en Belgique, c'est un gros problème qu'on rencontre, c'est que finalement, il y a une sorte de blackout au niveau des avocats, lesquels disent non, désolé, nous ne vous transmettons pas l'information car on a le secret professionnel qui nous impose de ne pas donner des informations.
Oui, c'est une très bonne question, Maître Vilmos, parce qu'en effet, avec les avocats, on discute aussi beaucoup. Et on discute beaucoup parce qu'ils sont aussi des entités assujetties, parce qu'ils sont exposés dans cette politique et ils ont des obligations d'entités assujetties. Mais c'est vrai que suivant la jurisprudence de la Cour de justice de l'Union européenne, et pas seulement, aussi au niveau national, les avocats nous disent fréquemment qu'eux, il y a ce privilège, de legal privilege entre le client et l'avocat qui fait qu'eux, ils ne peuvent pas respecter ou suivre à la lettre les obligations qui découlent de la directive et de la loi nationale qui la transpose. Mais je pense que ça, on est bien au-delà de ça. Et c'est pour ceci, afin de transmettre ou de disséminer, disons, plus largement au niveau de l'Union européenne, les obligations qui découlent de la directive. On a un programme qui est en cours, qui est financé par l'Union européenne, qui est en cours pour les avocats en Europe. Et on fait ça avec cette structure d'association des barreaux en Europe, afin de pouvoir to raise awareness sur le fait qu'il y a des obligations et que le privilège avocat-client ne peut pas être utilisé comme une défense pour ne pas respecter les obligations qui découlent de la directive. Mais ceci étant dit, je ne suis pas en mesure, je vais vérifier, mais je ne pense pas qu'on a une telle granularité des données pour dire si les notaires, je ne sais pas, en Belgique ou ailleurs, fournissent, disons, plus d'informations aux autorités concernées, aux cellules de renseignement financier, plus que les avocats. Je ne suis pas en mesure de dire ça. Je peux seulement vous confirmer que le privilège avocat-client a été fréquemment invoqué et que je pense qu'on avait un peu dépassé ce moment. Tout en respectant le privilège, il faut dire que le privilège, je le répète, ne peut pas être l'argument pour ne pas faire suivre aux obligations qui découlent de la législation contre le blanchiment des capitaux.
Merci beaucoup, Madame Prună, pour toutes ces informations, vos précisions et aussi le caractère direct de vos informations que vous donnez. C'est quelque chose qu'on apprécie beaucoup. Alors maintenant, on continue nos discussions. Vous êtes bien sûr la bienvenue si vous souhaitez assister mais je crois que vous avez encore une grosse réunion qui doit se tenir, donc vous devrez hélas nous quitter. Mais en tout cas, nous, notre porte ouverte, elle est toujours là. On est toujours là pour vous écouter, pour écouter vos conseils. Et on tient encore particulièrement ici au niveau de la CNUE à vous remercier de l'aide que vous nous apportez pour organiser ces différents séminaires. Sans vous, nous ne serions rien.
Je vous remercie pour l'honneur de m'avoir invité. On est toujours à l'écoute. Vous êtes les notaires, comme les avocats, comme tout le monde qui a des obligations qui découlent de la directive, nos interlocuteurs. Et encore une fois, il n'y a pas de réforme qui se fait sans discuter, sans consulter les parties de la société. Je vous remercie et à bientôt. Et bonne continuation de la journée.
Merci beaucoup.
Merci beaucoup.
Voilà, donc je crois que je suis déjà en retard, je suis désolé, mais bon, vous savez, on parle et finalement l'heure passe trop vite. On continue le travail. On a décidé d'organiser 2 panels de discussion. La première aura pour thème l'identification du bénéficiaire effectif dans les personnes morales, défis et perspectives. Comme vous pouvez voir, c'est un sujet très délicat et qui sera modéré par Madame Silvana Capello, qui est expert externe pour le problème de la lutte contre le blanchiment d'argent à UINL. Et puis le deuxième panel portera sur la question suivante: qu'attendent les autorités compétentes des entités obligées? Lacunes et moyens d'amélioration au niveau pour la collaboration. Alors là, ce sera modéré par Maître Karastati, désolé pour la prononciation, qui est notaire en Grèce à Évias. Voilà, je crois qu'on va directement entamer le panel 1. Est-ce que Maître Capello, Madame Capello, nous entend?
Oui.
Voilà, bonjour.
Hello, good morning.
Voilà, je vous donne la parole.
Thank you very much, Mr. Wilmos. First of all, I would like to thank the CNUE for inviting me to moderate this panel and to participate in this interprofessional seminar that you are organizing. Congratulations for the organization of this activity, because as we have seen, and as President Rouskas and Ms. Prună have said, this is a huge matter, which is a challenge for all the countries. So for this panel, that as you mentioned, is about the identification, the challenges in the identification of the beneficial owner of legal person. We have high-level representatives, and I think that we will have a good debate, because this is one of the most challenges, issues that have to be transposed by member countries. So first of all, let me welcome and introduce you the panelists. We have Mr. Rupen Manhart, who is chair of Anti-Money Laundering Committee of the Council of Bars and Law Societies of Europe. We have also Ms. Clara Borbonazzi. She's the manager of guidance and outreach in the Financial Intelligence Analysis Unit in Malta. And welcome, Clara. We also have Tom Van Otrieve. He's the product portfolio manager in FedNot in Belgium. Christine Cloquet, who is the vice president of the Accountancy Europe and member also of the Institute of Tax Advisors and Accountants. And Mr. Alexander Winkler, who is a civil law notary in Vienna. Welcome all you. Thanks for participating in this panel. And I guess we have chosen some of the most challenging issues regarding the identification of the beneficial owner. As President Rouskas and Ms. Prună said, you know that criminals employ a large range of techniques and mechanisms to obscure their ownership and control of illicitly obtained assets, and identifying the true beneficial owner or the individual who exercise control represents a significant challenges, not only for prosecutors, law enforcement agencies, and intelligence practitioners across the world, but also it is a difficult task for obliged entities. And we have seen there are many typologies that shows that schemes designed to obscure this beneficial ownership often employ a hide in plain sight strategy, and this leverage global trade and commerce infrastructures to appear legitimate. This is one of the most challenging efforts that countries may have in enforcing the national laws. We see, if we pay attention to the results, the last results that has been shown as result of the fourth mutual evaluation in the Financial Action Task Force that was published this October, at the beginning of this October, we can see that from 102 countries that have been assessed in this fourth mutual evaluation, there is only one country which is fully compliant with recommendation 24, which is about the recommendation of the identification of the beneficial owner. And if we go to the efficiency of the measures that member countries have, if we go to the immediate outcome number 5, which is related to this issue and is related to the use or access that authorities for money laundering and terrorist financing, the access they have to the information on their beneficial ownership, we see that only 10 countries have reached a level of efficiency, of substantial level of efficiency, and there is no countries with high level of efficiency. So clearly, this is one of the most challenging issues. And to begin with the debate with the experts, I would like to invite Mr. Rupen Manhart to make us a brief summary of the requirements the European directive demands from member countries, specifically in this issue of the identification of the beneficial owner.
Thank you, Silvina. I hope I I'm well understood. As you rightly mentioned, the Fifth Directive sets out some criteria which amend the criteria we had in the Fourth Directive already, in particular as regards to international cooperation. That means it is the goal of the Fifth Directive is to enhance identification and verification of beneficial ownership information in cross-border settings, because this has been identified as one of the biggest issues. The AML directive, the EU AML directive, remains largely unchanged in many parts as regards the definition of beneficial ownership. As you might recall, beneficial ownership is defined in a different way as regards corporate entities. We have this ownership criteria, 25% plus, and we have the senior management official criteria if you cannot identify ownership. And there are different criteria for trusts and similar structures. The directive lays down the CDD obligations in Article 13. The CDD obligations mean we have to identify beneficial owners, and we have to verify the identification of beneficial owners, which are two different sets of rules. And this obligation includes the understanding of ownership and control structures of entities. In the directive, again, largely unchanged, Article 14 lays down the criteria as regards to the timing of the beneficial ownership of the identification, so that you have to identify the beneficial owners before you establish a business relationship. And which is new, we have to, as obliged entities, we have to collect a proof of registration or an excerpt of a register if it's an entity which is subject to registration in the respective country. In Article 30 and Article 31, you have the provisions on the collection of beneficial ownership information, laying down again two different types of rules. The one relates to who has to collect the information, which are usually the entities themselves, and sets down a set of rules on registers. Already the Fourth Directive has put forward the provision on the installation of beneficial ownership registers, and now the Fifth Directive has amended it in a large part as regards the access to this information, as regards the control of this information, so that we as entities, for example, have to report discrepancies to the register. And which is new as regards the interconnection of the registers is that now the Fifth Directive has put down the obligation, put forward the obligation to interconnect the registers, but this is not yet in place, and is one of the biggest issues we have in practice also. Thank you.
Thank you very much. To begin with the debate, once we have clear or we have clarified which are the main requirements, I would like you to debate about what are the benefits of having and accessing the information for the competent authorities and also for the obliged entities. Clara, as member of financial intelligence unit, what is the benefit of having this information and accessing to this information about the beneficial owner?
So thank you, Silvina, for the introduction, and also thank you to the CNUE for organizing these excellent events throughout the year. To answer your question, just going to give some context. So I see that many audience members here, of course, are legal professionals. And one thing that we study, at least under English company law, is that a company or a legal entity has a separate legal personality, right? So whenever a company or a foundation is set up or another legal entity, you are creating something that has certain powers and certain rights, much like a human being like us. And so it is a very powerful tool because it allows people to establish business and even to carry out other activities. So not just commercial, but also personal, financial, philanthropic, or for estate planning, and so on. So as you know, legal persons can own properties, they can participate in contracts, they can take judicial action, and because the entity is separate from the human beings that are controlling it, it also creates some privacy. And traditionally, this has been desired. However, unfortunately, we know that this can be misused. So structures and the privacy that they offer have been misused to avoid tax, to defraud creditors, to launder dirty money, to move funds to be used to fund large terror organizations, and to circumvent sanctions. And we've seen the wrong use of legal entities. We know how these can be misused. We've heard of the Panama Papers, we've heard of the Luanda leaks. So this activity was made possible thanks to the lack of transparency that was offered. We saw how persons in very prominent public functions, very prominent public office positions held complex structures that offered maximum secrecy. Now, in most cases, these legal entities were what was protecting the criminals or was disguising the activity or the criminal activity from the criminal, right? And now, a fundamental requirement, of course, in customer due diligence is knowing who your customer is and being sure that they really are who they tell you that they are. The same for beneficial owners. So as Rupert rightly mentioned in his introduction, we need to identify and verify the customer, but also the beneficial owner. So at the very heart of beneficial ownership information, you have the need to know who owns or who is exercising control over a legal entity. Now, the FATF and the EU anti-money laundering directives, which are mostly based on the FATF recommendations, have always recognized the importance of identifying the beneficial owner. And countries across Europe have registries holding beneficial ownership information used for AML and tax purposes. But to answer your question directly from the point of view of a financial intelligence unit, which is where I come from, we need this information when we're assessing a case. So if we've received an STR or if we've received some spontaneous intelligence from a counterpart, we need to see which natural persons are behind the companies that are very frequently used as a channel to move a lot of money quickly from one country to another. So to give you an example, if our analysts are looking at a case and they've built up a case with lots of transactional links between multiple companies, so there are transfers of funds that look like trade or import and export, or as they're labeled as loans and loan repayments, and then it turns out that the natural persons, so the beneficial owners behind these companies, are all the same, or they're all connected somehow, then you possibly have a typology for trade-based money laundering. So we definitely need that information to be able to join the dots. And we obtain information, much like other countries, from the obliged entities themselves, and now, thankfully, also from the registries of beneficial ownership information. Having this information in a registry is very useful for financial intelligence units, and we will see that the EU and internationally we are moving more towards direct access to information rather than requesting it from different sources. And this has several bonuses. So first of all, it improves the operational efficiency for the financial intelligence unit because there are less requests to be made because we're querying the information directly from the source rather than requesting a number of banks to see if that person is their customer. Naturally, we will have the information instantly without having to wait for a reply. So this also shortens the analytical process, which is something that every FIU aspires to do. Even for the obliged entities themselves, there is a reduction in requests. So AML compliance can become slightly less of a burden, of a resource-intensive thing. And also especially when we're talking about very sensitive or very high profile cases, the less information we request from the obliged entities, the less chance there is of tipping off, right? Naturally, we've built a good relationship of trust with our obliged entities, be they notaries, be they banks, but we also have to accept that there is a small risk of tipping off. But if that does take place, the consequences are quite severe. And even for obliged entities themselves, the information held in the registry will help them to verify the information that they collected on their clients. So it's important to remember, at least in Malta, that the information in the registry doesn't replace the requirements to obtain the information by the obliged entity, at least not in Malta. So this was a very quick overview to put you in the context of how important this information is for a financial intelligence unit. Silvina, I don't know if you want to see the opinion or the perspective of the other excellent panelists that we have.
Yes, thank you, Clara. What about the obliged entities? The other panelists all belong to sectors which are obliged entities and are required to be obliged entities and to identify the beneficial owners. What is the benefit for you of having access to this information when conducting the due diligence or the identification of your customers?
Do you have anybody specific in mind, Silvina, or may I just step in?
No, okay. I only want to know what are the benefits you have found in having access to this information, of course, when conducting this the due diligence you have to comply with as a notary.
Well, first of all, thank you very much for the invitation, and I may just join Clara. The access to information is crucial in the fight against money laundering. More important, access to reliable information is essential to comply with the regulations. The better the informations are you can gather, not from your legal entity, but from, for instance, registers of beneficial owners, the better the information is that you can work in, and the better you can comply with your obligation as an obliged entity. And you have to keep in mind, as a notary, when you help your client or guide a client through a transaction, what did you do before the implementation of the AML directives? We had to establish who is the authorized representative for the legal entity and who is able to represent this legal person to conduct the transactions. For this, we have commercial registers in place in all countries over Europe and nearly all over the world, which can provide us with that information. But this information is not good enough for complying with the obligations under the AML directive. We have to keep we have to have a close look on the legal entities. We do not have to just only establish who is able to represent, but who is the beneficial owner. And to gain this picture, to gain this information, we need more transparency and more information. And this is what the registers of beneficial ownership are most crucial, and what we are seeing all over Europe being established right now in different forms. And I think we come to that point later on in the discussions. But to say in the beginning, the better register of beneficial ownership is, the easier it is for any obliged entity and any competent authority to gather reliable information and to also keep the costs of the transactions low, because you do not have to gather information several times on the same legal entity. Thank you.
Thank you, Alexander. This, I guess that some of the things that you and Clara have mentioned takes us to a second issue, which is which are the models and the systems that have been applied, at least in your countries. Do you have beneficial owner registries? and what are the minimum requirements for updating that beneficial owner information. And also, I would like to discuss about the steps that should be taken to undertake verification, because as Rupert said in the introduction, it's not the same identifying than verifying the identity of the beneficial owner. So my question is, which are the systems or the models that are in place in your countries regarding the beneficial ownership information, and how do the system ensures that the information about the beneficial owner is updated? What do the regulations say? Maybe Tom, do you want to open the floor on this?
Yeah, okay. Thank you for having me. In Belgium, I am part of the Federation of Notaries, FedNot, and in my position, I'm offering tools and systems for the notaries to do their job, basically. As we all know, in 2015, the European Union passed this directive 2015/849, which installs an obligation for companies and other legal entities to collect and keep adequate, accurate, and up-to-date information on their beneficial owners. And this directive clearly states that the data will have to be recorded by the companies and other legal entities in a centralized database offered by the state. This directive has been transposed in Belgian law in 2017 on the prevention of money laundering and terrorist financing, and it establishes the what we call the UBO registry, the Registry of Ultimate Beneficiary Owners, within the General Treasury Administration, which is part of the Ministry of Finance. There is a public access, let's say, that has been built that gives the administrators of companies and other legal entities the possibility to enter the information, the data about their beneficial owners directly in the UBO registry. This is an obligation in Belgium since September 2019, so it's been in place for a year now. FedNot, as the Federation for Belgian Notaries, offers or will offer very soon a possibility for the notaries to consult this UBO registry, so where they can consult the ultimate beneficiary owners of their clients from within their notary environment very soon. However, we wanted to take this a step further in Belgium, and because we see that by putting the responsibility to fill in the registry of UBOs entirely with the administrators of the companies, we see that, or we notice that it's very hard for them to fulfill their legal obligations, because for them it's not so easy to understand what is a beneficial owner, what criteria have to be met, when do they have to be filled in, and there's even an obligation to, even when nothing changes in their structure of their ultimate beneficiary owners, for example, they have an obligation to yearly reconfirm their situation, even nothing has changed. So we also believe that we should have, let's say, a platform that gives all the professions involved in the anti-money laundering and in the identification of ultimate beneficiary owners the same data, the same view on their clients. So what we did in Belgium is we built an interprofessional platform called eStocks, which is basically an online register of shares for companies, where the notaries and accountants and tax advisors all together, they will register the situation of the shareholders in companies in Belgium. And this, we believe, offers many advantages to the companies themselves, because we rely on the data that they provide us. And we see that there's let's say a weak point there. You need to get access to that data from the companies themselves. So you need to give them also a kind of positive story so that they are willing to give that information, and it's not just a legal obligation with punishments and everything. So we have a direct link between this register of shares called eStocks and the UBO register. And whenever there's a change in the structure of the shareholders in a company, eStocks will automatically calculate if there's also a change in the ultimate beneficiary owners. And if so, it will automatically transfer this data into the UBO registry, which makes it a lot easier to fulfill this obligation for the companies to fill in their ultimate beneficiary owners in the registry. Also, those yearly reconfirmations are done automatically by the eStocks, the online system platform. So it knows when there has not been any change in the shareholders of a company, and it will automatically reconfirm the situation in the UBO register. And so the UBO registry always has an up-to-date information about the ultimate beneficiary owners of companies. And eStocks can also be used by the companies for other, let's say, positive purposes like corporate housekeeping, calling their general councils of shareholders and all of these things which they have to do anyway. But they can now do this in a digital way, so it gives them a lot of advantages. This shareholder registry is, by the way, also a legal obligation for companies to maintain. So by just having their shareholders documented by their notary or by their accountant or tax advisor, whoever they see or want to see at that point, they have two legal obligations. One is for holding the register of shares, and second is the obligation of filling in their ultimate beneficiary owners. So, and by this interprofessional collaboration between notaries and accountants and tax advisors, we are very close to the companies because they have frequent contacts with the companies, and we are able to get very accurate data on the ultimate beneficiary owners and up-to-date data. So that is the, let's say, landscape of the systems that we have in place in Belgium.
Thank you very much. Clara, Alexander, you mentioned that you have in your countries the beneficial owner registries. I would like to know which are the mechanisms to update the beneficial owner information, and how often the information should be updated. Only when there is a change on the shareholders, or also they have to confirm if there has been no changes. How does it work in your registries?
May I step in, Clara? You want to answer first, or shall I step in? Okay.
You can go for it, Alexander. Thank you.
Okay, thanks. In Austria, we've established a register on UBO, an ultimate beneficial owner, called in German the Register der wirtschaftlichen Eigentümer. This is a completely new register which has been implemented and is run by the Ministry of Finance. It's not an extension of the commercial register, which is run by the Ministry of Justice and the courts in Austria. The register on beneficial ownership does gather information on itself from other registers which are run by public authorities. The register of beneficial ownership gathers information from the register from a commercial register, for instance, from the population register. It combines this data. It tries to work on an accurate picture of the legal entities. And also there's the requirement for the legal entities itself to provide information to the register. If you do not comply, you will be fined by the fiscal authorities. And you have any legal entity has the obligation to check their information at least once a year. And for instance, when changes in the beneficial ownership do happen, which are not imported from, for instance, a commercial register. So when a shareholder of a limited liability company changes entering the commercial register, this data is then delivered to the UBO register. What the Austrian register cannot do is access foreign registers. So for instance, when a legal entity has ultimate beneficial owners who are registers in a foreign commercial register, the legal entity then itself is obliged to provide this information to the register. Nonetheless, this register does not provide information with good faith as a commercial register, but if an obliged entity, for instance, a notary or a bank, does find the register does not reflect or correspond to its own findings, it conducted, for instance, during an onboarding process for the clients, the obliged entity can and is required to make a note to the entry of that legal entity so that other obliged entities do know that the information of the register might not be accurate and will have to continue further investigation into that legal entity to determine the beneficial owner. So this register is quite complex, it's quite extended, and it does provide a very good information on beneficial ownership because it does not only rely on the legal entities itself, it gathers information from other sources, it compiles that information, and then it provides a bigger picture. This, once again, it's not only relying on the information of the legal entities itself, because as Clara also said, if somebody wants to conceal something, they will probably not comply with the request for information. So if you can get information from independent sources, it's always better than just to rely on the legal entities itself. So this is probably quite a good and probably a best practice model around Europe, this Austrian register. Thank you very much.
Thank you, Alexander. Clara, how is it in Malta? Which are the mechanisms you use to update the information on the beneficial owner you have in their registry?
So in Malta, the registry there are different registries, of course, for companies, for trusts, and for foundations. So these are all different registries. But the one for companies is run by the Malta Business Registry. So it's overseen by the Malta Business Registry. And I think we have some members present as well for this meeting. And if I am not mistaken, so any changes have to be notified within 14 days. And then also, if I'm not mistaken, every year a company will have to submit a confirmation of the current state of beneficial ownership. So either confirming that there have been no changes, but the information itself is submitted by the companies themselves. So by each company, each company will have to submit beneficial ownership information to the registry. And there are, but I don't know if we're going to mention these later, methods of enforcement. There are penalties associated. If I'm not mistaken, in the mutual evaluation report, the penalties were considered as not being high enough. I don't know whether these have been revised, but I think it seems to me that they are quite significant. So they range from 5,000 euro to 10,000 euro, depending on the breach. But then there is also a daily penalty up until the time it would take to to actually rectify the issue. So this is in brief the system. Unfortunately, I don't have much more detail on the mechanisms of verifying the information from the side of the MBR. However, I do believe that they have the power to go on site to the company and verify the information. So there are also some mechanisms to ensure the verification, but the penalties also tend to be quite effective.
So thank you. We have mentioned many times that the European directives and also the FATF recommendations require that member states to ensure that the corporate and other legal entities which are incorporated within their territory obtain and hold adequate, accurate, and updated information about the beneficial ownership. And these terms, the scope of these terms have raised many issues on the interpretation of this. What is accurate? How do we ensure accuracy and adequacy of the information? Alexander mentioned that in the case of Austria, the registry do not rely only in the information provided by the legal entity. But my questions regarding this are, do you consider that it should be clarified what are the necessary elements of the beneficial owner information that must be collected in order to consider that that information is adequate? And also regarding the accuracy, should this beneficial owner information be verified, and what should be the minimum requirements of this verification? How the registry could verify, or what should it do in order to verify information provided by the legal entities in cases where registry is only made of information provided by these legal entities? And one last thing is regarding the update of information. What do you think are the key elements of this timeliness? Do we need, or there should be a specific time frame to update the beneficial owner information? Clara mentioned these 14 days. How do the registries ensure that legal entities are providing the information on beneficial ownership on time, and they are updating this beneficial ownership information which is in the registries on time? So I don't know who wants to open the floor on this. Maybe Alexander, if you want to begin with this.
Yeah, thank you, Silvina. I can try to pick it up. Minimum requirements, very good idea and a very good step forwards to standardize and harmonize information on beneficial ownership, at least within Europe. It shall be noted that harmonization is a step towards a level playing field within the European Union, and we will prevent the opportunity of a so-called forum shopping in the context of providing transparency. We do see this forum shopping in the field of commercial registers, that companies who are able to move across borders try to find the jurisdiction which suits them best, and probably if you try to conceal information, you will try to find a jurisdiction where it is easier to conceal information than in other jurisdictions. So harmonization and standardization will enable us to have a level playing field all over Europe. And once again, we will not give the opportunity for forum shopping in this context. The verification, as you said, Silvina, also will lead towards more reliable information and more assurance for obliged entities. And also it shall be noted that a good and reliable information in the register will also lower transactional costs for businesses, especially small and medium enterprises, who cannot imply one of the big four consulting firms, for instance, to take over that work, because they will not have to provide the same information to different obliged entities. Imagine a client purchasing some real estate. He will have to give the information to the notary who conducts the transactions. He he will have to give the information to the bank who gives them the loan for the acquisition of the plot of land. And if this small and medium enterprise will only have to provide this information once, for instance, to a good register, and all obliged entities can access that information in the register, you have lower costs for this SME, so you can cut red tape, to say so. We do know from our experiences in the fields of commercial registers in different systems within Europe that we have different forms of commercial registers. We have some forms which are at least, let's say, more reliable because information in the register is verified. It's either verified by courts. It's every commercial register knows information verified by other independent authorities, independent office holders, which are notaries. And we do know that notaries play an essential role in a system where you have a strong and good commercial register. So it would be fairly easy to facilitate the knowledge and the experience of the notaries also in this fight against money laundering, providing transparencies. And please bear in mind that notarial instruments, notarial deeds are more reliable source of information than other information provided by the legal entities themselves. And we do know this from practice that other obliged entities are relying more on information which has been checked by an independent authority, might it be a court, also a notary, than information just given by the legal entity themselves. And for the last question, to keep in the time frame, Silvina, the time frame to update the information, the beneficial ownership, should be, let's say, without unnecessary delay, immediately, and also as soon as possible. Because, and bear in mind, the more reliable such registers are and the more accurate information they provide, the more they will be used. And the more they will be used, the more the legal entities themselves will be interested that the beneficial ownership register reflects precise information. And this will incentivize those legal entities to provide this information to the register as soon as possible. So setting up a good register will incentivize the legal entities to have interest in accurate information, that the legal entities themselves will be interested to have the information entered into the register as soon as possible. Thank you very much.
Thank you, Alexander. I would like to invite the other panelists to share your opinions on this. We have also Christine Klocker from the accountancy sector. Christine, how do you see this?
Thank you. Am I heard? Yes? Okay. You hear me? Yeah? Okay, good.
Yes.
So first, I would like to make a few introductory remarks because, as you said quite correctly, I'm coming from the accountancy side and also from the tax advisory side. Not lawyer, but tax advisor. So I've worked more than 30 years as tax advisor, and I have an education of accountant, and I've been also working with accountants and auditors during all that time. And a first preliminary remark is that our interactions with our clients as tax advisors and or accountants are normally on a very long term. And let's say we accompany our clients as the notaries do, but the notaries sometimes it's more, let's say, topical, because maybe during 3 years there is nothing happening with your clients, and then suddenly they are coming and they have a lot of things to ask. With us, it's separate. From there, I would say that the first one question was, what are the benefits of having this information about UBOs? Well, from a tax advisory point of view and also accountancy point of view, it's very important for us because it gives us more sources of information about the structure in which our clients operate. And therefore, we are able, if you know your client more, you are able to advise him normally better, okay? Because you can maybe be proactive and make him or her think of things. For example, in tax advisory, tax planning, etc. So that's the first thing. Now the verification and so forth of information, that I think has been covered. So we have, of course, to do that as well. I should say also that in Belgium, the tax advisor or the accountants, from an anti-money laundering point of view, and this, the UBO register makes part of the law on anti-money laundering, we are subject entities to that legislation, of course, and even the institutes, where the Institute of Accountants and Tax Advisor, to which I'm a member, I belong, and also the auditors, etc., the institutes themselves are obliged entities. So that's also a dimension because the institutes then have really the obligation to support their members, to give them information, etc., so that the members apply that correctly. So that's also a specific dimension. So it's a bit of a revolution, because when now you start your relation with a client, you have to ask him a lot of questions, etc. In the bigger firms, we already did that, but in the smaller firms, normally, sometimes that's a family business. You have been working with your father, and then you take up, and you know your clients, etc. Now, no, you have to do that more formally. So I think it's a good thing. Now, one remark also about Belgium and the update of the information. Normally, the law is that the information has to be updated within a month of the event giving rise to the updating. Okay. Now the lawyers and if the obliged entities notice that there is a difference between the information that they have in their files and what is published, they must change that in the UBO register. The lawyers, of course, had a problem with the professional secrecy. They pleaded their case because they need to be able to defend people, even if those people have very complicated and illegal structures. And so they plead their case with the Council of State. And it's very recent, but a few days ago, it has been published, let's say. There is an article of a royal decree of execution of the UBO legislation saying that we must do this update. This article has been, for the moment, abolished. So for the moment, but I say for the moment, and maybe in 2 weeks it changes, for the moment there is, let's say, a vacuum. Okay? So that's one thing. But that came about because of recourse filed with the Council of State by the lawyers, but it's applicable, let's say, to the obliged entities. And so here I had this question, what are the main problems you have in the verification of their identity? Well, with the UBO, for us, it's easier now, but sometimes it can still be very complicated because in order to be included in the register, you need to have a certain minimum shareholding, 25%. But then to calculate this limit, there are some detailed rules. And that can also depend, for example, on the nature of the wedding contract. Okay, so you may have to do, let's say, some analysis. Of course, you can liaise with a notary. But let's say, so that can be pretty tricky. And also, once you come into the chain of entities, and when you do tax planning, that is quite common. Then once you reach, let's say, countries which we are not a lot in contact and so forth, that can also be a bit difficult, but we do what we can. Other sources of information to cross-check, well, we tried already before the UBO to do that. Yes, it exists, but I cannot go in detail. We have, for example, of course, the identity documents, publications in the Belgian official gazette and things like that. Have you detected any transaction intended to conceal the identity of beneficial owner? Well, if you ask me, with the number of years of experience, that is, I have had cases, yes, where we had clients who wanted to become clients and we did not accept them. And that was long before the UBO, because indeed we could not obtain evidence of who was at the basis of the structure. So that was long before the UBO, but the UBO now will help, I think, to spot that quicker. And so therefore also you lose less time and money trying to get this information, because your responsibility is also even separate from the AML, your responsibility is also engaged. So for the moment, we do not hear a lot from the members of the Institute about what they find out since this new system. I think maybe it's still a bit early. So from that point of view, I don't have a lot to report. I think that the fact that now we, as Institute also, we give them seminars, etc., and we insist they have quality reviews, and if they do not comply, then there are sanctions as well on the members, so the accountants and the tax advisors. I think that helps, and so therefore, up to now, we do not notice a lot of problems, but it is let's say a revolution, especially for the small practitioners, because there, and I will finish with that, there, as I said, the toponymy was, okay, I have a limited number of clients, we are working with 5 or 10 people in my office, we know our clients for years and years, so no problem, we are safe, okay, from an AML point of view and UBO, etc. And then the family becomes older, you may have a generation gap, and then at some point you notice, and we see that in the declarations which have been done in the past years by accountants to the crime unit, if I may call it like that, that there is a new shareholder coming, and the father maybe, or the grandfather who is still there, allows someone new to come into the shareholding. The younger family, especially if they do not care too much and if they are not active, okay, they don't pay too much attention. And apparently our National Crime Unit says that now for the last years, that is a typical, let's say, pattern, a typical pattern for money laundering people to penetrate the medium size or the smaller entities, and then gradually then taking power in there or buying then the rest of the capital, and then they are at home, let's say. And in the past, okay, that was maybe not spot very often, whereas, or only after a period, whereas now with the UBO, that will also help, I think. I hope this contributes to the reflections, and I hope that it meets your question. The answer meets your question.
Thank you, Christine. Thank you for not only for responding to the question, but also for introducing the last topic to be debated and for answering to the questions I was going to formulate. For the other panelists, I would like to know what are you doing in your sectors to verify the identity of beneficial owners, and what are the main problems that you have had in the verification on the identity? What other sources of information you use for cross-check information? Clara said or mentioned that in Malta it is clear that information on the kept in the beneficial owner registries is not enough in order to consider and does not replace the obligation of verification on the identity of beneficial owners that obliged entities have. So what other sources of information you use for cross-checking the information you find in the beneficial owners registries? And lastly, if you, as Christine mentioned, if you have detected any transaction clearly intended to conceal the identity of the beneficial owner in your professional activity.
If I may step in at that moment from a lawyer's perspective, well, we do transactions, but we do other things as well. From a point of view of transactions and beneficial ownerships, I must say I'm based in Austria as well, so there might be a little too much of Austrian perspective in it. The Austrian register provides for extended excerpts, meaning there's a standard and there's an extended excerpt. And if you have the extended excerpt, you don't need more information to verify the beneficial owner, except for a confirmation of the senior of the management saying, well, the register is still accurate. So in practice, this is the register is not sufficient, but the register plus confirmation of the management, and that makes it quite easy on national transactions. The real issue is with international transactions. If we look in international transactions, we don't have access to international registers. Often registers need a registration, you need to pay fees, etc. So even on a European level, we cannot easily access other European registers. And if we leave the European Union, if we need information from other countries, it is quite often very difficult to obtain such information in practice because there are no such registers in place. And then we need, and usually we need original documents in order to verify this information. For instance, I had one transaction which might be the horror of the horror to identify and verify the information. Several trusts linked to each other, some based in the British Virgin Islands, and in such a transaction, you need weeks to establish the links. You need to collect original documents in order to verify them, and that's at the end of the day, original documents are the only way to verify this information. Thank you.
Thank you, Rupert. And I guess that as you have responded also from the Austrian side, I will allow Alexander, if he doesn't want to, and given that we have time constraints, to respond about that. And as Christine has responded also from the Belgian perspective, I guess, Tom, that you would not have so many information to add. Clara, do you want to point something about Malta? I know that before continuing with Clara, I know for the organizers that we are already over the time that we have. So if you can be brief in order not to delay the second panel, I would appreciate that.
Thank you, Silvina. So in the interest of time, I think we can proceed with the discussion. A lot of the things a lot of the questions that you just asked were addressed throughout the discussion. And I think the importance of beneficial ownership information for both the obliged entities, but also for the FIUs, that importance has come out now. So thank you for moderating this discussion.
So thank you all. I guess that we have made a good approach on the challenges and the prospects that the identification of the beneficial owner base for countries, not only from the competent authorities perspective, but also from the obliged entities perspective. I guess that we can conclude that there is lots of work to do in this field, and certain clarification is needed, and especially certain development from countries to increase, especially the accuracy of the information that we have in the beneficial owner registries, which are already created. So I guess that we can open to questions in case any of the participants wants to raise a question. We would appreciate to identify the person you want to do the question to, or if it is open to any of the participants of the panel. Thank you very much.
Yes, so we have the first question from Mr. Beldens of the Belgian Federation of Notaries, and I will leave him the floor. He can unmute his camera and microphone. So, Mr. Beldens, can you hear us?
Oui, moi je vous entends, mais est-ce que vous m'entendez?
Oui, on vous entend.
Vous pouvez poser votre question.
Voilà. Donc je suis au service donc de la Chambre nationale des notaires en Belgique. La question qui est vraiment la question centrale, et on l'a abordée, mais ça vaut la peine de revenir là-dessus. Ma question est vraiment comment assurer la qualité, donc la fiabilité des informations enregistrées dans le registre national des bénéficiaires effectifs. National, je veux dire au niveau de tous les États membres, hein, donc chacun des registres nationaux des bénéficiaires effectifs. Comment arriver à assurer cette fiabilité? Alors, je donne comme exemple, en Belgique, la création d'une société à responsabilité limitée, comme une société anonyme ou comme une société qu'on connaissait, la SPRL, qui est devenue la SRL en Belgique, elle doit être créée par acte notarié. Et à ce moment-là, effectivement, le notaire va identifier les personnes et va vérifier les personnes sur base de pièces justificatives. Mais ensuite, en Belgique, la cession des actions, eh bien, elle échappe, donc la cession des actions de cette société échappe complètement à l'acte notarié, donc au travail de vérification du notaire. Naturellement, c'est une faiblesse, c'est une réelle faiblesse. Une des options, c'est effectivement, vous voyez venir, c'est d'aller vers ce système. Est-ce qu'à l'heure actuelle, du côté européen, dans les autres systèmes nationaux, est-ce qu'on a un système qui fonctionne bien à ce niveau-là et qui a fait ses preuves jusqu'à présent et dont on pourrait s'inspirer? Voilà ma question.
So thank you very much for your question, Mr. Beldens. Who wants to respond to that? Does someone wants to respond the question?
If I may not respond the question, but in a certain way second the question, because in fact it is a problem. We have on the one hand we have the goal of the European Commission to deregularize the market, to make access easier to the market on the one hand, and on the other hand we have the requirement to verify, to identify beneficial ownership. So both goals are conflicting, and I'm not aware of any national system who actually can bridge this gap. On the one hand, you have the notaries, of course, and if every transaction must be notarized, you have it's a good proof to and you can easily follow the beneficial ownership. Some systems rely on banks because they often hold information on identification as well. But apart from those two systems, I'm not aware of any system who actually gives proof and follows the beneficial ownership if in transactions if you transfer ownership. But that's something we know. By the way, if you look in large companies and stock companies, Société Anonyme, in such setting, you never had this. So we always had the issue that beneficial ownership was not controlled if we transferred stocks in large companies.
Thank you, Robert. Just to add a few things, as you know, just to respond to the question, as you know, member countries have chosen different systems, and the approach for the verification of the information is different in each of them. In the case of Spain, for example, that is one of the countries that has a level of substantial efficiency. The beneficial owner registry or the beneficial owner database is held by the notaries. And in the case of Spain, the sale of shares has to be made before a notary. So even when a company is constituted and also when the shares are sold and there is a change in the ownership of the shares, those transactions has to be performed before a notary. So with this transaction, this beneficial owner database is fitted and is updated. And in the case of the notaries in Spain, the database is updated every 15 days. So at least in that case, they have the opportunity of having the information from the original source, because it's the own notary, the ones that fits the beneficial owner database with the information obtained from the transactions that have been made before a notary. So in the case of Spain, 92% of the companies are limited liability companies, and those companies have the obligations to be not only constituted, but also the sale of the shares have to be made before a notary. That's a way of ensuring in a certain way the reliability of the information. But as we have heard, there are different systems, as they mentioned, panelists mentioned also. In Austria, they have chosen the system of feeding the beneficial owner registry with other public sources, other information obtained from other registries. So the mechanisms are different, but I totally agree with you that there are certain issues, and one of the main issues regarding the information held in the registries is the accuracy of the information due to the, in some cases, lack of verification of the information.
We have one final question by Mrs. Aida Oksha. She will receive an invitation to speak. Please unmute your microphone. Can you hear us?
Hello?
Yes, the floor is yours.
Dear all, do you think the countries who aspire to be part of European Union have difficulties on meeting the criteria for money laundering? If yes, which are the main reasons?
I'm sorry, who is the question for? Do you have a specific destiny for the question, or any of us is yes, good to respond?
Yes.
My opinion, why the European, or why the countries that wants to enter the if I didn't understand wrong, what are the problems that they are facing, or why they are facing problems with the anti-money laundering regulation? Well, as you know, the European directives, they all come from the FATF recommendations. They are based in the FATF recommendations with a few differences. One of the few differences is regarding precisely to the need of, or the existence of beneficial owner registries. But most of the anti-money laundering regulation is quite homogeneous. It has to be quite homogeneous due to the FATF recommendation. So the FATF recommendation and the FATF-style regional bodies, they all enhance member countries to comply with the recommendations set by the FATF. So the regulation is expected to be quite homogeneous. Some countries are developing. I'm sorry. I'm hearing voices. That's why I stopped. But it is expected to be homogeneous. So those countries that wants to be part of the European Union, as they are already obliged to comply with the recommendations, should adapt the regulations to the small differences that the directives have regarding the recommendations, but they shouldn't have biggest problems on that.
Thank you very much. Yeah. Thank you very much. Thank you very much, dear Silvina. I hope the answer was listened by the participant who asked the question. I would like to thank you, dear Silvina, you are our colleague from the International Union of Notaries, and this shows cooperation between the European Association and the International Association of Notaries. We are very happy that you accepted the moderation of this panel and the entire, let's say, intellectual logistics behind. Thank you so much to the participants, Madame Cloquet, who is with us here in the CNUE studio, and to all the participants, Alexander, Mr. Vanotroy, Clara Bonacci from Malta, and Mr. Rupert Manhart from our colleagues, the lawyers. Thank you so much. Let's have a break, I suggest, of 10 minutes to let our dear interpreters to breathe. And please grab a coffee, please take a glass of water, and let's see each other at 11:50 for the second panel, which will be moderated by our Greek colleague, Eftichia Karastasi. Thank you. See you later.
Thank you very much.